You do like 15 seconds. Okay. All right. Eric, anytime you like.
Good afternoon. I'm Eric Lieberman, a second-year student at the University of Pennsylvania Law School, and today we are joined by Clinton Bamberger, the former dean of the Columbus School of Law at Catholic University, the former assistant attorney general of the state of Maryland, and the first director of the legal services program within the Office of Economic Opportunity. Mr. Bamberger became an honorary fellow of the University of Pennsylvania in 1981. Thanks for joining us today.
I should have worn a blue shirt, right?
Looks like a fine color to me.
Yeah, looks
Oh, it is
good.
blue.
Yeah,
Good.
we're rolling. I was wondering
Okay.
what kind of joke you were going to make there. So listen, we're rolling. You guys have a nice conversation.
Thank
okay?
you very
Okay,
much.
thanks a lot.
Duck down here and you're on your way.
When and where were you born?
In Baltimore, would you believe it, 1926.
What were your parents' occupations?
Well, my good Lord, the last time I was asked this was when I had some credit card transaction. They always want to know my mother's maiden name. My father was an accountant, but he really got his college degree and his accounting degree after I was born. My mother finished secondary school. She didn't go to college. Her father was a immigrant from Sicily, if you would believe it. If this is in color, that may be hard to believe. And my paternal grandfather was a German grocer, a stoic German grocer.
Do you have any siblings?
Yes, two. Both younger, sister and brother.
What career paths did they pursue?
Well, my sister was a teacher and a preschool proprietor, I guess you'd say. My brother was in a Jesuit seminary, but he's about 6'8" and weighs about 350 pounds. And I think they thought it was going to cost too much to clothe him. And I think he also began to understand the vows of poverty, chastity, and obedience, so he left before he was ordained. And he lives in Phoenixville, Pennsylvania. Maybe I shouldn't reveal that. And he's was in sales.
Was
and
the Bamberger household a strict household growing up?
Well, when I think of all the things I got away with, I'd say no. No, I don't think so.
Was the importance of education and scholarship emphasized by your parents? And was reading or music encouraged at home?
Well, yes. I mean, my mother, being of Italian ancestry, played the Metropolitan Opera every Saturday. But I mean, I think my true answer to your question is not to a great degree, though I do remember that my father and mother, I think, were conscious of sort of their social status, that they weren't quite, mind you, this is in the 30s and the 40s when there was a great deal of pressure to be a white Anglo-Saxon. And I can remember, for instance, my father bought some course on pronunciation, and I remember learning to say forehead. You didn't say forehead, you said forehead, which seemed to me strange, but I do remember my father and mother sort of being concerned about that. And reading, yes. I mean, particularly I had an eccentric grandmother who would go to secondhand bookstores and always bring me books that she'd bought for 10 cents.
Was your family politically active?
No.
Were you conscious of political issues at a young age?
Well, I was conscious of them, but probably in sort of negative ways. I mean, I just was thinking this is probably more psychoanalysis than I've had for a very long time. My grandfather, see, I come out of German and Italian Roman Catholic stock. And in that era, the 30s, 40s, 50s, that was pretty conservative because they were essentially an immigrant population, excluded from a lot of from jobs and from education. When I went to law school, Catholics didn't apply to Ivy schools because you knew they had quotas. I think they admitted a few more Catholics than Jews, so we always felt a little better about that. But they had pretty strict quotas. I remember that my grandfather used to listen to Father Coughlin. Now that doesn't mean anything to you, but Father Coughlin was a very right-wing Roman Catholic priest in Detroit, I think in Detroit, who had a large national radio audience, and he was very conservative. I think he was pro-Nazi. I think he was anti-Semitic. But I can remember my grandfather, the stoic German grocer, who I probably never heard say 10 words in his life, listened to Father Coughlin every Sunday afternoon. I don't remember my parents now they all voted Democratic. I mean, they were all Roosevelt Democrats. We didn't tolerate, there was no intermarriage with Republicans. We didn't tolerate that. But they were essentially conservative. I mean, Baltimore was a very segregated town. Baltimore was a town segregated in all kinds of ways, not just Jews and blacks, but Germans and Czechs and Eastern Europeans lived in one part of the city, and Mediterranean people lived in another part of the city, and Jews lived in another part of the city, and blacks lived in another part of the city. So I grew up in a very segregated society. I grew up and went to a church, a Roman Catholic church, where the last three, this is into the 50s, the last three pews on the right had a little sign on them that said colored. And with a swimming pool, and this is a neighborhood that was immediately adjacent to the Jewish neighborhood. So the swimming pool, not public, but a private for profit, had a sign that said approved Gentiles only. Now mind you, that didn't allow all Gentiles in, just approved Gentiles in. But the only Gentiles they approved were any Gentile. They just disapproved any non-Gentile. And that included they didn't even think about blacks then. One didn't even think about that. But
So you became aware of social injustice in America at a fairly young age?
I think so, yeah. Well, I became much more aware of it, I think, when I was in college. There was much more, that was just before the Second World War. So actually it was right after the war. And there was a beginning then of a social conscience about racial issues, and particularly in some parts of the Roman Catholic community. I mean, the Roman Catholic communities, the churches always had strong social gospels that they kept secret until sometime in the 40s or the 50s.
How did the Great Depression affect your family?
Well, I don't remember much, except that I remember that money was very tight in our family. For instance, you had to take 10 cents to school to get a Jill, a half pint, or a pint of milk. And I remember that my parents sort of were concerned about whether they had the dime every day. And I guess it was kind of a looming dire possibility. So, you're always sort of conscious that might happen, but not much more than that.
Where did you attend high school?
I'm a product of Jesuit education. I went to a Jesuit high school in Baltimore, and I went to Jesuit college in Baltimore after the war, and I went to a Jesuit law school in Washington.
Did you have any favorite subjects in high school?
Lunch. No, I was a very good student the first year, and not after that, which is a very bad pattern, because then you're always told you always got chastised more severely because you can do better. Why don't you? It's so much better to sort of start off weak and then keep getting stronger. I started off strong and got weaker. And mind you, this was a time I started high school doctor. Do I get a box of Kleenex while I'm sitting here for the, in the 1940s? And this was, the war was coming. So I wasn't that much interested in staying in school as I was in going off to the war.
So did you work during high school?
Well, I worked from the time I was 10 in my grandfather's grocery store, delivering groceries. I know the back doors of every fine residence in downtown Baltimore because his store was in the middle of the city at a time when that was where the business leaders of the city lived in the downtown, and they all had tradesmen's entrances, and I know where they all are.
How did the Second World War affect your high school and college experience?
Well, what I remember are terrible prejudices, and I really do mean prejudices against both Germans and Japanese, that although they were doing evil things, the sort of tales that you were told, at least with respect to the Japanese, I think, but maybe not so, but the tales that you were told were, I think, worse than the reality, as bad as the reality was. And I remember once we had a teacher of Greek who was part Oriental and part European, and we treated him miserably. I associated with the worst people in school, I guess, but I mean, we treated him, mocked him as being Japanese. I mean, unless you lived through those days, you don't know how bad they were. In the First World War in Baltimore, had a large German immigrant population, and so there was a street in the middle of downtown called German Street. And in the First World War, that name was changed to Redwood Street. And German language wasn't taught in schools then. So, I mean, unless you sort of lived through those wars, you don't realize how the kind of public manifestations of hatred that existed in the cities. Now, I was only in the Second World War. I enlisted, and I was only in for a year because I enlisted in the Air Corps, and suddenly they found out as the war was winding down, they didn't need any more pilot. I was enlisted to be a pilot, a navigator, or a bombardier, and they decided they didn't need them, so after the war ended, we were not yet eligible for discharge because we hadn't been in long enough, we hadn't been in combat, we hadn't been overseas. They discharged us with the intention of drafting us back in, but if you discharge 30,000 people, most of whom came from literate families, the political pressure was such you're never going to draft them back, and so we weren't.
You attended Loyola College in Baltimore,
Yeah.
graduating in 1949. What other colleges did you consider, and why did you ultimately select Loyola?
I think I considered Georgetown, but on the day that the principal of the school was going to recommend me for Georgetown, I hooked school. The first day I ever hooked school in my life. And I used to have to walk or hitchhike to school, and I went by a wonderful lake, and it was a spring day, and I couldn't resist. When I got on the bridge over the lake, I took my clothes off and dove in the water and stayed there. I came home, my mother said, "How was school?" I said, "It was really good today. I really enjoyed it." Well, what did you do today? "Oh, I think we had this subject." I said, "Did you?" And then she told me the principal had gone to look for me and to talk to me about filling out this recommendation for Georgetown, and he couldn't find me. So he called my mother. And then when I came back from the war, so I started at Georgetown, and then I had actually enlisted, but they weren't calling us up for a while. And I just was there for, 8 or 9 months at Loyola. And then when I came back from the war, I just decided I wanted to stay home, although I hadn't really been, I hadn't been out of the United States. And there wasn't there wasn't a culture or tradition in my family of going away to college, and there wasn't a tradition I don't think I ever heard anybody in my family talk about Ivy League. I didn't know. I thought that was some softball league or something. So there wasn't a culture of that. The culture was get a college education. And my father had gone to to Loyola, which is a Jesuit school. And there was also a culture then in the Roman Catholic Church then of that these schools that weren't Catholics were beds of atheism. You'd lose your faith and virginity, not necessarily in that order, but both pretty quickly. And this is a time of sort of, you're talking about an immigrant population who were mostly Irish, at least on the East Coast, and in Baltimore many were Irish, and led by Irish, who had a great ghetto mentality. And you had schools. Schools were still, they counted the number of Catholics they had. When I went to the law firm, I was, first they thought they were hiring their first Jew, which they didn't really want to do, and when they decided I wasn't a Jew, they hired me. And then they told me, now I must tell you at this point, one, I'm not under oath, and secondly, one of the things that happens to you as you go through life is I sometimes remember things I should have said when something happened, and then I remember I think I said them, and then I remember I said them. So I don't exactly know what the truth is about all these little things, but my story about that is that when shortly after I was at the firm, somebody said somehow this subject came up. There were no Jews in the firm, no women. We were all white males. And somebody said, well, you should be perfectly comfortable. There are 2 other Catholics here. So they were counting them.
You attended Georgetown University Law Center, graduating in 1951. Why did you decide to attend law school?
I have to tell the truth. Well, because I knew I didn't want to sell. I didn't want to go. Business didn't appeal to me. I didn't know much about it, but it just didn't appeal to me. And law appealed to me because it sort of was kind of non-restrictive. It was sort of inclusive. I thought about a lot of things if I went to law. I didn't know any. I knew one lawyer who was a classmate of my father's. I didn't know him very well. I think he had an individual practice, but I didn't really know any. I didn't know much about the law. I went to the law school for the same reason that most law students who will tell you the truth went, because they didn't know exactly what they wanted to do, or they didn't get into medical school.
Did you consider any other schools?
I considered medical school, and I didn't get into medical school.
Did you enter law school with intentions of practicing public interest law?
What was that? There wasn't anything called public in 19. When did I go to law school? 1949. There wasn't anything called public interest law. Absolutely nothing. The word didn't even exist. There's an article, you can read an article in the Yale Law Review written in, I think, the late 60s, that for the first time, to my memory, certainly not the first time, but that defines what public interest lawyering is, because it wasn't a word. No, it was far from my mind. I think somewhere in the back of my mind, I had some notions about being active in the community. And that was something that I think lawyers did. So that was somewhere in the back of my mind. But mostly the reason I went to law school is that I'd been to enough family Sunday dinners where maiden aunts and other people wanted to know what I was going to do. And I found that when I said I was going to medical school, they really liked that. That was approved. And so that ended the conversation. They didn't keep pestering me. And when I didn't get into medical school and I said law school, I got the same response. They thought that was good. I mean, it's like sort of being it's like what the Jewish mother said, which do you want to be, a lawyer or a doctor? So both of them satisfied people, and it avoided, I had the GI Bill, the great GI Bill, and my tuition was paid for, and I got $50 a month, which would support me.
Were there any areas of law that particularly interested you in law school?
There must have been some. I suppose, it sort of depended on the teachers. I think constitutional law. This is also a time at law schools when all of the young teachers so many of them had been killed in the war. And many of the people who were teaching had graduated from Harvard the year before. And it was also a time when I went to law school in 2 years. You went all year. If you were a veteran, if you'd been in the war, and so there wasn't you almost didn't have classes because people were graduating every other week almost. At least every semester people were graduating. But I guess for some reason property interested me. I sort of took all the property courses. This is also a time, when I don't think there are any electives. Any. So it's kind of difficult to get very interested in something that you're told you must do. But I did take there were electives and advanced electives, and I took all the way up to Property 3. I can't understand that, but I did.
Why did you decide to clerk after graduating?
Because it seemed to me a way that I could learn about what the opportunities were. And it would be an opportunity to observe lawyers. I thought it was a good way to get a job. Mind you, there weren't many clerks then. This was only the third year that where I clerked, which was the Court of Appeals of Maryland, the highest state court. It was only either the second or the third year that they ever had clerks. And I happened to know a fellow who had graduated from Georgetown the year before who was a clerk. But it wasn't, I clerked for 2 judges, one of whom wrote most of his opinion by copying Corpus Juris Secundum, so we didn't do very much work for him. The other one was a really very bright, brilliant lawyer, and he was a good mentor. And it was a way in which you could get a job. I clerked, the Court of Appeal was in Annapolis, and we lived in Baltimore. And there was another clerk, a fellow who graduated from Harvard named Herbert Scharf, who was a clerk with me and lived in Baltimore too. And what we would do every day is we'd call the lawyers who had the first case to argue the next morning. and say we needed a ride from Baltimore to Annapolis. Well, as I say, clerks were a new institution, so they didn't know quite what we were, but they thought they better, be nice to us, because at least some of them thought we wrote the opinions. So God, these guys would say, certainly, where can I pick you up? We said, no, you tell us where you're going, we'll be there. I mean, they would bend over backwards to pick us up, and then we'd talk to the lawyers who had the last case and ask for a ride home. And Herbert and I both kept a copy of all these names, and then when it came time, our job was just for 9 months. And when our clerkship was ending, we wrote to all of them and asked them for jobs. So this was before law schools were placements agencies. I mean, law schools were not primarily employment agencies in those days.
So firms didn't come on campus to recruit?
No.
Not like today?
No. I mean, we could wear dungarees all year.
Did you work on any decisions during your clerkship that you were particularly proud of or that impacted you in a profound way?
The latter part of it, I don't think so. No, again, clerking was a different sort of a field, of a job then. The judge would sort of give us, would ask me some particular question, and to keep me busy while he went off and wrote the opinion. No, I still have all those memos, which I wouldn't dare show anybody, but I do have them. No, I don't really remember.
But you felt the experience contributed positively to your career?
Well, I think I learned, at least by osmosis, yes, I think so. I mean, it helped me get a job, because I finally got a job at Piper and Marbury because a lawyer named Dorsey Watkins had given me a ride down her back, and I wrote to him, and he remembered my name and had me come see the firm.
Did the experience nurture an interest in public service?
Did what?
Did the clerkship experience nurture an interest in public service for you?
No.
In 1952, you got married to your wife, Catherine. How did you two meet?
Good Lord, Doctor. I mean, are you from the law school or the School of Psychiatry? How did we meet? I was at Georgetown Law School. I was, believe it or not, a prefect. I was a house father in the undergraduate dormitory at a time when, and you won't believe this, undergraduates were required to be in their rooms at 7 p.m., 9 p.m., and in bed at 11 p.m. with their lights out. Can you believe that? Can you believe that? This is 1949, 1950. And I got room and board for checking them, making sure they were in their room, and making sure they had their lights out at 11 o'clock. And so anyway, then there's a Catholic girls' college on the other side of town called Trinity College, which is a good school, has good, bright people, and also has some wealthy Irish girls, sons of Irish contractors or something. And there was a young lady who I won't name who was very wealthy, and I dated her. And one day she asked me if I had a date with her, and I think I'd finished law school. I was back in Baltimore, and she said, could I get her a blind date? I did. She said, he has to be tall. I did. And the person that my friend had a blind date with was Catherine Kelleher, and that's who I married. And I'll tell you another piece about that. I mean, this isn't very serious. I mean, I can't imagine that this is, you can always cut things off of this tape, can't you? All right. But just a funny story. I had a friend named Gene Fitzgerald, who was a law student and a prefect with me, and he and I used to ride back and forth. The Georgetown Law School is in downtown Washington. The university is out on the fringes of downtown. And every day Gene and I would come back from the school and we'd go to the mail. We had a mailbox with the students, and we'd go get our mail, and Gene would say, "Hey, look, I got an invitation here. You know that girl, Catherine Kelleher? She's asked me to come over to the hot dog fry or something." And a week later, I'd say, "Hey, Gene, I got a letter from Catherine Kelleher. She asked me to come to the sock hop or something." Catherine was chasing both of us. And the pressure got so intense that Gene went off to the Jesuit seminary. And then Catherine and I got engaged, and within weeks after that, Fitzgerald came out of the seminary. So I always accused Catherine that she drove him in, and that when he thought it was safe, he came back out. Cut that out of the tape, or I'll be in serious trouble at home.
In 1952, you also joined the law firm of Piper Marbury.
Right.
What attracted you to this firm?
A job. I was looking for a job in Baltimore in private practice. It was then the largest firm in Baltimore. 2 firms of 7 lawyers each had merged. And one of the partners had given me a ride, and I wrote to him and got a job.
What were your tasks as a new associate?
I mean, this is a world you have no idea what it was like, okay? I mean, this is a law firm that didn't have carpets on it. It was the leading firm in Baltimore, and the floors were not carpeted. They were, linoleum. And this was the leading firm. The head lawyer, William Marbury, was a great lawyer. He had been general counsel to OSS during the Second World War as a young 40-year-old lawyer. He later, subsequently he became the one of the members of the Harvard Corporation. The 5 who run the institution. And he had connections. He was the lawyer in Baltimore for any kind of sort of major commercial work. But there were no dictating machines. There were no Xeroxes. At my first office, they had the 9th floor in a building, and when I came, they didn't have space, so they leased a little suite of 3 offices on the floor below, and they had wonderful golden oak furniture. I don't see any here, but and the first 2 of the offices in that suite were filled with old golden oak furniture that they weren't going to throw away because they might need it, and I was in the 3rd office. Now, you guys wouldn't even accept a job with anybody like that now, right?
Probably.
Yeah. So what were my tasks? Well, there were, I don't know, maybe 10 partners and 4 associates, and you were just live meat. Any partner that you didn't specialize, whatever some partner who had some particular piece of work and needed some help on, you did, and mostly you did. Obviously, you did research. I remember one of my jobs was I straightened out the library. They had a library, must have had maybe 1,000 volumes in it, but when the 2 firms merged, they just threw all the books in a room, and I, given my Teutonic sense of order, I put them all on the shelves in the right order. And that was expected as an associate. Now, you guys wouldn't do that. You wouldn't even, a paralegal wouldn't even do it now. So you did all kinds of things. And we did cases, before the Workers' Compensation Commission. We did subrogation cases for insurance companies where you were claiming $135, which was kind of good because those are the things you got to do. You got to do everything.
Did you have any partners that served as mentors for you?
Yes, yeah, at least I can remember 2 particularly. And I remember once for William, I can tell you one time that William Marbury mentored me, and I could take you back. I think they just tore the building down, but if it was still standing, I could probably show you the blood stain. he had a case called Miller and Company versus the state of Maryland. It involved, it was a very important case. This was in the Supreme Court. It involved the question of, well, this is when sales taxes were beginning to be enacted, so this is in the 50s. And the question was whether Maryland could collect a tax on a sale made in Delaware, because lots of people, you know, would, to avoid the Maryland tax, would run over to Delaware and buy the living room suite. And so this was an important case. It was going to the Supreme Court. And he asked me to, there was one little issue in it, which is, if I remember it, was that the way they got jurisdiction over this Delaware company was to seize one of its trucks when it came into the state. And I think the question that was raised was whether if the judgment exceeded the value of the truck, well, I don't remember it well enough, but it had something to do with whether or not how the size of the judgment would affect their ability to sell the truck or something like that. So I went to the bar library, because we didn't have big farm libraries then. We didn't have, there was no Lexus and no Westlaw. Did you know that?
I didn't know that.
Yeah, well, it didn't exist. And I researched it, this question, all the way back to the English common law precedents. And I wrote this maybe 5-page memorandum. And Marbury now had asked me to sort of write that piece of the brief. Or I don't know if he said that. No, I think he just said, you know, he wants some research on this question. And I came back and I gave it to him, and he said, fine, I'll look at it and I'll give you, we'll talk about it. And he read it and called me back in the office and said to me, Clinton, that's a very nice law review piece, but it's not an argument. And I bled. But that taught me from that moment on, when I looked at any part of a brief that I wrote, I didn't look for scholarship first, I looked for advocacy first. So that was a piece of mentoring. And another mentoring thing was, there was another lawyer who did a lot of trial work, and he was very good at it. One thing I remember about him is that he would have a case, and so he'd go in the law library, in the little firm's library, and he might remember some case, and he'd pull that book off the shelf. He wouldn't shepherdize it, or then, you know, try to see whether it had been adopted in other states or something. He'd just sort of take that case and carry that book with him. And he might not even know what the case was, but he carried the book with him. And that was enough. He'd then make his argument and keep referring to the book, even though it may not have anything to do with his argument. And I always remembered that. I never tried a case when I didn't always carry a law book with me. And sometimes I hadn't opened it at all, but I'd put little pieces of paper in it. It would make the other side very nervous, because they'd look at the volume and it wasn't one that they recognized as having any cases in it that had anything to do with the case that was being argued. And then they'd see I had these little paper marks in it, and they thought, oh my God, you know, we've missed something. But he taught me something, I'll tell you, all right? One day he said to me, he said, Clinton, we were doing a lot of insurance defense work for the Travelers Insurance Company. And he said, I've got a conflict. I've got to be somewhere, and there's this jury case to be tried. A woman fell getting off a bus or something. That's what it was, I think. And he said, I want you to try it. I said, Jesse, this was in the Court of General Jurisdiction, the jury court. I said, Jesse, I've never tried a case in that court. In fact, I don't think I've ever sat in that court during a trial. I said, another place I've tried cases is the People's Court, which is a court of limited jurisdiction, no jury. Oh, well, he said, don't worry, just, you know, the same kind of arguments you're making to the people, the judges down the district court, you just got 12 of them now to argue to. And so we went over to do the case, and he said, I'll go over with you and I'll introduce you to, it was a judge named Warnken, who was a very strict man. And Jesse said, I'll introduce you to him. So we went in chambers before. Jesse said, Your Honor, this is Clinton Bamberger, an associate in our firm. He's going to try this case. Oh, very good, Mr. Bamberger. Very nice to have you in court. And Jesse said, Your Honor, oh, no, and the judge went on to say, Mr. Bamberger, I'm sure that you have sat at trials with Mr. Slingliff and Mr. Watkins and Mr. Evans. He sort of named the litigation partners. And I thought, I don't want this guy to think that I know what I'm doing here. So I said, no, Your Honor. I said, I've never been in a jury court before. At which he proceeded to dress down Jesse, give Jesse hell, and feel sorry for me. So it all worked out all right.
Did you manage to fit? Well, first of all, did the notion of
You don't want answers that long, do you?
That's fine. It's good. First of all, did the notion of pro bono work exist?
What does that mean? No. There wasn't any term for it.
Right.
But everybody did it. What it was called was the guys that didn't pay, clients who didn't pay. And it was also, well, there was a sense of pro bono, yes. And certainly in Piper and Marbury there was a sense of pro bono. Now it had different definitions for different people. For some people it meant helping out your cook's son who had been arrested for throwing snowballs. For others, it meant, and it also was a time, of course, when there were no staff public defenders, so that you were given criminal assignments. If you look at, I remember there's a case called Betts versus Brady. Do you know Betts versus Brady? Oh, now I have something to say about Penn. Betts versus Brady preceded Gideon. Have you had constitutional law, criminal law?
I might have been exposed to it, but perhaps didn't remember.
I want to ask you a few questions now, all right? Anyway, Betts versus Brady is the case that preceded Gideon. Betts versus Brady, in effect, said, under the Constitution, you're entitled to counsel in a criminal case depending upon the complexity of the matter, depending upon whether you really need a lawyer to do it. And Betts versus Brady came out of Maryland and was argued in the Court of Appeals of Maryland by two lawyers from Piper and Marbury when the chief judge of the court called them up and said, would you come argue this case? So there was that kind of pro bono. And there was lots of others. I mean, I guess I had sort of become involved in community things, and mind you now, we're coming into the age of the Civil Rights Revolution. And I don't remember how, but I used to always have something that wasn't billable time. But I didn't know what billable time was then. Mind you, this also, sir, is before there were computers. And in fact, we didn't keep time. We billed a client for what we did, not how long it took us to do it. And while I was at the firm, I was at the firm for 17 years. While I was there, we began to keep time. So I didn't, at the end of the day, I couldn't tell you how much time I spent on pro bono.
In 1958, you represented the Smoot Sand and Gravel Company in Bostitch versus Smoot, involving a dispute over the removal of substrate from the Potomac River. During the pendency of the action, Smoot actively and successfully urged upon the General Assembly of Maryland the adoption of a statute which limited the granted rights to riparian owners of lands. Do you view such activities as an unethical means of bypassing the judicial system? Boy,
you found my Achilles heel. The answer to your question is no, I don't. I'm not sure I thought about that before. I don't see. Yeah, Smoot was a raptor. He had made a fortune taking sand and gravel out of the bottom of the Potomac River to build all the buildings in Washington. And the Potomac River is different than I think every other river in the United States, in that the dividing line between the states, Virginia is to the south of the river, Maryland is to the north. The dividing line of the states is not the thread that is the middle of the river, but is the low water mark on the Virginia side. And so Smoot would buy he'd buy the riparian rights from a Maryland owner, or he'd buy, a 3-foot strip of land, and then he'd own all the bottom. And that question was challenged when a number of very wealthy people who had built homes, very expensive homes, and I actually think one of them was one of the lawyers with the firm that were representing them, had built very wealthy homes right next to Mount Vernon. And so Smoot, this great raptor, moved his terribly noisy dredges into the river right under these guys' homes, these beautiful homes and views that they had. And so they hired Ginsberg, Leventhal, and somebody, a very powerful Washington firm. Harold Leventhal was the treasurer for the Democratic National Committee or the party, and later was a brilliant lawyer, and later became a excellent judge, a renowned judge on the D.C. Circuit. And they brought this case. And in the course of that case, they introduced the legislation. I'll tell you the ticklish thing about that. I was at the firm working as an associate with a good lawyer named Evans on trying this case. And then, before it had gone to the Court of Appeals, while it was still in the district court, maybe it hadn't gone to court yet at all, I went to be an assistant attorney general. An assistant attorney general in Maryland was a part-time job. The whole attorney general's office was not more than 8 lawyers. And all of the major firms, sort of the people that were considered up-and-coming associates, and I'm talking about 4 firms, would be asked by the Attorney General to come there and work for 2 years. It was great experience for a young lawyer, and the firms were very pleased to have you do it, because if you went there and were counsel for the insurance commissioner, when you came back to the firm, you certainly could be helpful to the firm's insurance company clients, so it benefited the firm too. And I went off to do that. Now, it was you could continue a private practice while you were in the Attorney General's office. You didn't have to give up all your practice. And so I continued to be working on this case. And Smoot had for a long time retained as his counsel a Southern Maryland lawyer who owned a lot of land there. No, he wasn't a lawyer. His wife was a lawyer. A Southern Maryland legislator who was the president of the state senate. And Smoot had him on a retainer, I think, which worked out probably to about $1,000 an hour, which was a lot of money. I mean, that is, he didn't get paid. The amount of retainer that he got and the amount of little bit of work that he ever did probably meant that he was being paid about $1,000 an hour. And he was a good guy and a perfectly honest guy. I went, and this legislation was introduced. I think he introduced it. It had been part of his retainer duties, you see. I don't remember what the legislation did, but I know it would win the case for us. I'm not sure I think that's wrong. I mean, that's an interesting question. I'm not sure I've ever thought about it before. I'm not sure it's wrong if a matter's in a court that forecloses you from taking the problem to the legislative body and asking them to address it. What do you think about that?
I don't think it's necessarily wrong either.
Okay, all right. How'd you do on professional ethics?
Professional responsibility.
Yeah.
I'm in it right now with
How are
Professor
you doing?
Lesnick. I'm doing all right.
Okay, all right, I'll take your answer. And I went to see Louis to talk about something. And somehow I mentioned that bill. I don't remember why or how. But he got very disturbed because he thought that I was offering him, the context of the conversation was such that he could have thought that I somehow was offering him something in exchange for him to really support that bill hard. And as I say, he's now deceased. He was an absolutely honest man. And he got very angry at me because he misunderstood me. And I explained that to him. But then in the course of that, I don't know if your research, do you know there was a hearing? I was questioned about that, called as a witness. Well, Smoot, the Ginsburg, Leventhal, and something firm had associated themselves with a lawyer in Baltimore named Lawrence Weissman, who I would not recommend to you as a mentor. And I would tell you, Weissman subsequently left Baltimore and worked with Roy Cohn. Roy Cohn, who was on Senator McCarthy's staff, and who was a lawyer who I also would not recommend as a mentor in New York. And so Weissman was, to say the best, very aggressive. And so they filed some kind of a motion in the district court claiming that I had somehow done something absolutely unethical and so wrong that it not only disqualified me from practicing law, but that it also meant that Smoot should get judgment in the case. I don't remember what the theory was. And the firm, again, to sort of tell you how firms worked then, I mean, once you went to a firm, you were expected to become a partner. You were a part of that family. And so the firm hired a lawyer to represent me because they called me as a witness. And the inquiry was whether I had violated the canons of ethics or some other professional standard. And my testimony was taken by this guy, Larry Weissman, and you're bored, and that's the end of it. All right. Okay. That's all. But I mean, that's it.
No, you can go on.
No, that's all. That's all the way. I
Okay.
mean, it's just an interesting part of.
A McCarthyist.
Well, no, I mean, it was a mistake of mine to ever. The mistake was to continue to be an assistant attorney general and involved in that case at a time when it was being considered by the legislature. That was a mistake. And whatever I said to Louis, to the president of the Senate at that time, that he misunderstood, that was a mistake. But the one lesson to learn out of it is the culture of firms then was such that the firm had no hesitation. I mean, nobody quizzed me at the firm. I told them what happened, and they hired a very good lawyer, one of the kind of the best lawyer in Baltimore who wasn't in our firm, to represent me. And I became partner after that, so I was only an associate, I think, yeah.
Did the nature of your work change following your tenure as Assistant Attorney General? The nature of your work at Piper Marbury?
No, because everybody was a generalist. It just changed because I had sort of evolved into being a trial lawyer.
In 1963, you mentioned you'd done some representation on the Blackburn case.
Yeah.
which involved Earl Leroy Blackburn, who was convicted along with another man, Frederick Mefford, of first-degree murder and the fatal shooting of a gas station attendant.
Terrible thing. He made the guy kneel down and beg for his life and then shot him.
During the course of a
The
robbery.
last time I knew Blackburn, he was out of jail and working as a barber. I always thought, my God, I suppose I was getting a shave and looked up and saw Earl there.
And Mr. Blackburn was sentenced to death.
Right.
The circumstances under which Mr. Blackburn was questioned were a point of contention. Mr. Blackburn stated that he requested the assistance of a counsel and was repeatedly denied. He also claimed that his confession was coerced through misinformation regarding the felony murder doctrine. The Maryland Court of Appeals affirmed the conviction, yet 6 years later the conviction was overturned by the U.S. District Court for the District of Maryland. Do you feel such abuses by law enforcement authorities happen more often then or today?
I don't have any idea. I don't know. I really don't know. I really don't know. I mean, there are too many factors you have to think about. I think we've become much more conscious of the racial divide, the racial disparities in criminal justice. I don't know. I think no. I don't know. I don't know that. Let me say, I originally represented Blackburn. I don't know. I think I represented him because that was before we had a salary public defender, and I think some judge called me up and said, would I represent him? I did not represent him at the trial. I've never represented a defendant in a capital trial. I've only on appeals. Once I did, but I disqualified myself once I was appointed. And I think Blackburn, some judge called me and asked me if I would represent him after the decision in the Court of Appeals of Maryland. And I was working on it, but then I went to work for the War on Poverty, and another person in the firm, I think maybe Larry Scriggins, took it over.
What is your opinion of the death penalty?
I absolutely oppose.
In 1965, you became the first director of the Legal Services Program within
Can I talk to you about a more important death penalty case?
Certainly.
All right. See, you're going to get long responses sometimes, even if you don't ask the question. All right. The legal case I'm proudest of is the Brady case. That's Brady versus Maryland, the case that holds that the prosecution is required to make available to the defense any evidence that they have, even exculpatory. And there's actually a book about it by a man named William Hammer. It's called something about his death somehow in the title, but that was a case again where a man had been convicted of murder, of a felony murder. Brady and a man named Boblet ambushed a friend of an older man that they knew on his way home to work, and while he was driving up a wooded road, and he was killed. I don't know who killed him, and I don't think they do. One of them did, but I don't think they know which one. Brady had been represented at trial by a paid attorney that the family scraped together money to hire. Brady came from a white sharecropper family from southern Maryland. Southern Maryland is slightly south of Oxford, Mississippi. So his family had no money. And this lawyer went to sleep at times during the trial. And at that point I have to say, we read, one of the things that bothers me now is that we read about defense lawyers in capital cases going to sleep. And sometimes, not always, the verdict is reversed because of that. But what I don't hear is what happens to the lawyer. Does any bar association then call the lawyer up and take away his license for that kind of conduct? There may be some, but there are not enough of them that you hear about it. That's your generation ought to address that question. Anyway, I agreed to, do you want to hear about this case?
Absolutely.
Okay. So I was asked, how did I get in the Brady case? Oh, I had a teacher in college, a man born of a Jew who became a Jesuit. Now, if you don't think that's a mixed up guy, but he was a wonderful man. He was the chaplain at the jail, and he never met a guilty man. So his name was Meyer Toby. He's deceased now. And Toby would always call me up and say, I've just met so-and-so. It's a terrible tragedy. He's here, and he didn't have anything to do with it. Of course, I'd go talk to the guy and find out he had a lot to do with it. But so he asked me if I'd come talk to Brady. It was actually, I think, the week in which Brady was to be executed. And so I went to talk to him, and then said I would look at the record.
Remember the microphone next to me. It slipped right off.
Oh, okay.
Yeah. Can you see how that clip goes right there?
Yeah. Where do you want it? Here?
Right there is fine.
Sorry.
All of a sudden I heard the sound drop away. I look up.
So if that was good, huh?
No, you were right in the heart of your story.
So I went to see Brady, and I said I would look at the record and see what I could find. So I got the record, and I think from the Attorney General's office. And now I mentioned Attorney General. Can I tell you something else? Say to me at some point, Attorney General / Candor, and then I'll remember what it was, okay? So I read the record, and there wasn't anything in the record that this man had gone to sleep to in the trial, because judges' clerks don't want to write that down. It would upset the judge. And I couldn't find anything in the record that seemed to me would justify a challenge to the conviction. He had been convicted. It had been appealed to the Court of Appeals, and they had affirmed it, so he was to be executed. But what I did find was that there were 5 statements by the they were tried separately, and there were 5 statements to the police by the co-defendant. 4 of them were admitted in evidence. And if you read them, they began, of course, with the co-defendant having absolutely nothing to do with the crime. But as you read the 4 of them, progressively his involvement became greater. And then there was this 5th one that wasn't admitted. He hadn't signed it. And the defense, the prosecution offered it, and but then withdrew it when the defense objected and said, well, he didn't sign that, it can't be admitted. Of course, it could be admitted. I mean, the fact that he didn't sign it, if they proved the circumstance which was made, it could be admitted. And the prosecution didn't press on admitting it. And I thought, well, at this point I'm looking for straws. I'm just looking for tiny straws. And putting together the circumstances that these confessions or statements had progressively implicated the co-defendant or the co-defendant, co-accused, and that the prosecution didn't press to admit this when the judge first said he thought maybe it shouldn't be admitted. I tried to get a hold of it. I couldn't get it, so I got my friend Father Toby to talk to somebody he knew in the state's attorney's office down there in the county and get it. He got it, and I read it. And in that statement, this guy, the co-accused, admitted that he killed the man. Brady and he, Brady had impregnated Boblett's sister. And Boblet said to Brady, what are you going to, you got my sister pregnant now. What are you going to do for that child? You're just going to run away? And Brady said, no, that child's not going to have the kind of life I had as just having nothing. I'm going to get some money and I'll take care of your sister and the child. And they then sat down and decided that they would go rob a bank. And they decided they'd get a car by this elderly man had befriended Brady, and he lived back in the woods, and he went to work every day, and he came home in the middle of the night, and they decided they would ambush him, tie him up, put him in the back of the car, go over and rob the bank when it opened in the morning, drive back and put this guy in where they knew there was an empty house, a farmhouse down in southern Maryland. They'd put him in the house, and then they'd take off for the south and call the police and tell them they ought to go let this guy out of the house. But somehow when they stopped the car and the elderly man got out and they told him to, and they started to tie him up, somebody, one of the two of them, garroted him, killed him. And they then never went over to rob the bank, but they just started driving south. And actually, I mean, you really ought to read the book because Brady went on, somehow got to Cuba and met a cab driver and said to the cab, this is when Fidel Castro was in the Hill, and Brady said, I'd like to go to see Castro. And the cab driver said, okay, you'll meet me such and such a place, I'll take you up there. And so that was like, he was to meet the cab driver that night or the next day. And then Brady's conscience really hurt him. Brady had never been arrested before in his life. Never been arrested. So he went to the embassy and he said, I was involved with the murder of a man in Maryland. And the embassy said, well, come back at 4 o'clock this afternoon. There'll be somebody here to talk to you about it or something. And meanwhile, the embassy tried to find out about it. The police hadn't yet found the body of the victim, so they didn't know anything about it. So Brady went back to the embassy, still wanted to turn himself in, but they wouldn't take him. Eventually, he told them where the car was or where the body was, and they did arrest him, and he came back for trial. But so that's the only piece I found, only hope I found, this statement. Oh, I went to the attorney, who was sort of the old line criminal defense attorney in the county seat in a town south of Baltimore. And I said to him, I said, George, do you remember that the prosecutor gave you some statements that the co-defendant made? Yeah. How many did he give you? I don't know. Well, George, you got your file? No, I don't think I have my file anymore. Well, George, did he give you 4? Oh, yeah, he must have given me 4. Did he give you 5? Well, I don't know. I don't think so. And I said, well, you know, there's a 5th statement that helps Brady, that implicates Boblet. Oh, he didn't give me that. Now, I have no idea whether that was true or not. I have no idea whether that was true or not. And I have to say to you also that as I think back on it, that's the answer I wanted from Wolfel. Well, it's on the record. That's the answer I wanted from the defense attorney. And I may well have said to him something like, well, George, you know, there's a 5th statement that implicates Boblet and exonerates Brady. He didn't give you that, did he? I don't remember how I put the question. But it's one of the things you've got to be careful about as a lawyer when you're discussing a case with a witness. Or what we used to call horse shedding a witness. Have you ever heard that term? In the old days, have we got till tomorrow to do this, or we got to finish today? In the old days, next to every county courthouse were horse sheds, because you came to the county courthouse in your buggy, and you had to put your horse somewhere. And so you'd meet the witness in the horse shed and talk to him about the case. You won't find anything in professional ethics about your conduct when you're horse shedding a witness. It does talk about your conduct when you're preparing a witness, but that's different than horse shedding. So anyway, that's something you have to be wary of. I knew the answer I wanted Wolfel to give me. And the question that I don't remember, maybe conveniently don't remember now, is how I put the question to him. So on the basis of that, we had a procedure just enacted in Maryland then called post-conviction, where you went back to the trial court and claimed an error after all appeals had been exhausted, and it was sort of a substitute for habeas. And you went back, and so I went to the trial court, and the trial judge, and the only point I raised was that the defense attorney said to the prosecutor, please give me all the statements that the co-accused made. And if the prosecutor only gave him 4 of them and not the 5th one. And the counsel, Brady's counsel at trial, got on the stand and of course said that. And I don't know whether it's the truth or not, because he was not, he was getting elderly. He's probably younger than I am now, but his memory wasn't very good, and he didn't keep his files. And as I told you, I think he had narcolepsy, or he slept, actually would fall asleep, and the clerks would wake him up. The court clerks would wake him up. And then then the prosecutor went on the stand, who was, to my memory, a good guy, a decent prosecutor. But he said he gave them all to the counsel. He said he gave all 5 of them to him. He didn't have any receipt for them. It was just his memory. The trial judge didn't believe him and believed the defense counsel. And that's always sort of convinced me that that was probably the truth. Because here was the trial judge who had this state's attorney before him every day and must have known him very well, and also often had this defense counsel before him and knew him well. And the trial judge chose, in a direct contradiction, chose to believe, and a direct contradiction in a case that challenges the trial judge's decision and punishment. The trial judge chose to believe the defense counsel's story on the side that challenged this judge. And then the case went to the then the state, of course, appealed it to the Court of Appeals of Maryland. And we went there to argue it, and I had a pretty good case that, this really deprived Brady of constitutional rights, although there wasn't any case squarely on point, as I remembered, but there were certainly something close. There wasn't anything from the Supreme Court that clearly held. And at the end of my I was the appellee, I guess. Yes, because the state must have appealed. At the end of all the arguments, the chief judge of the court said to me, well, Mr. Bamberger, if we agree with you that, and the finding of fact that this statement was not given, what do you want us to do? Because this only goes to the punishment, not the guilt. Even if the co-accused is the man who did the murder, your client was participating in the felony of robbery and is guilty of first-degree murder. So this question only goes to guilt, not to punishment, not the guilt. Well, stupidly, I hadn't thought about that question. And it may also surprise you, this was a time when, nobody mooted this case with me at the firm before I went to argue in the Court of Appeals. I wrote the brief. I don't think anybody else read the brief, and I went to argue the case without, maybe over lunch I talked to somebody in the firm about it, but we didn't moot cases, appellate arguments. I suppose we should have. The question hadn't thought about it before, but I thought, well, I don't know the answer, but I'm not going to give up anything. I'm not going to say, so I said, I think Your Honor, the relief I want is, it seems to me it goes to the heart of the verdict of guilt, and that the whole thing should be reversed. Well, the Court of Appeals didn't agree with that. And what they did, luckily for me and my client, they ordered a trial on punishment only, a retrial on punishment only. Now, Maryland had no bifurcated trials. You tried a case, and at the end, the jury decided in a first-degree murder case, they decided not guilty, guilty, or guilty without capital punishment. And the judge then imposed the sentence of either capital punishment or something less. So, but there were no bifurcated trials. It was all one trial. So I thought, well, that's pretty good. We'll go back and have that trial. And then one day I was talking to one of the other lawyers in the firm about the case. Like, this was about maybe a week before the time to apply for cert expired. And he was much smarter than me. And he said, you know, I think you got a federal constitutional question there, and you ought to ask the Supreme Court for cert. So I had never done anything in the Supreme Court, except that failed paragraph for Marbury in the case, and or that magnificent law review article that he didn't think would fit in the brief. I remember that we put together a petition for cert and drove over to the court, and he drove, and I got out of the car and ran up there just as the guard was closing the doors for the day, and got the cert petition filed on time, and lo and behold, the court granted cert. And I'd never been in the Supreme Court before in my life, so I then wrote the brief and filed the brief, and the state filed their brief, and I went over to argue the case. I went over the day before just to see, which door you went in and where the court was as opposed to the men's room, but I also had to know where the men's room was too. That's what I wanted to know, where the men's room was and where I would sit in the courtroom. Those were the two things I had to learn. And then I went over to argue it, and Father Toby and my wife went with me. Again, if you believe this, nobody in the firm ever talked to me about the case. And I guess this kind of gets to the pro bono thing. People knew I was doing the case, and they knew I'd won in the Court of Appeals. They knew I'd filed the cert, but nobody talked to me about the case. We never mooted it. Nobody looked at my brief. Maybe one of my contemporaries looked at my brief. And I went over and argued it, and I have the tape of that argument, and nobody will ever hear it. Nobody. I mean, it is shockingly terrible.
Were you intimidated?
I was scared terribly.
Who was the most intimidating justice?
Well, I don't know if I was intimidated by the judge. I mean, actually, I wasn't smart enough to be intimidated. No, I really wasn't. I was very nervous, but once I got up to argue, I was at ease. I mean, I wasn't, and I'd worked very hard on thinking about what I was going to say and making a kind of an outline of it that I had a loose leaf book where I had the outline but also had all the backup stuff, so I felt pretty good about it. But the argument, if you listen to the argument, it's pretty apparent after a while that I didn't have the ear of the court. I was getting questions, and I responded to them as well as I could. With hindsight, it wasn't very good. But the best appellate arguments I've ever made have been in the shower the day after the argument in court. I mean, I've always thought what I had to do was sort of somehow arrange things so that I would take the shower just before I went to court. And I'd think that I'd been there and I'd gotten rid of all that anxiety and tension about making the argument so that my mind got clear enough to really think about the substance. But what I do remember about intimidation, what I remember is that when I was getting to what I thought was the crux of my argument, Justice Douglas had been writing a letter, and he put the letter in the envelope and picked it up and stuck out his huge tongue and ran it across the envelope. And here, Your Honor, do you know I'm saying the most important part of this argument? So that was a little unnerving. The other part that was sort of unnerving is that they had these very strict time limits. And of course I had to be there at 10 o'clock in the morning. And then they didn't get to us, and then they say, well, now you go have lunch. Can you imagine having lunch when you're getting ready to make your first appearance in the Supreme Court? But I actually did have some lunch. And then when they got to the end of the day, my opponent, the Assistant Attorney General was arguing the case, didn't quite finish his argument, and we had to come back the next day. See, I had to go home and try to sleep. And of course, think of all the things I should have said, but in rebuttal I wouldn't be able to say. So that was all pretty kind of scary. And Douglas wrote the opinion. Now, the important thing, I shouldn't say important, I don't know if it's important enough, interesting thing is, I lost in the Supreme Court. What I was asking the Supreme Court to do was to send this case back to Maryland and tell them that they had to try it on both issues, punishment and guilt. And the Supreme Court, in an opinion that I don't fully understand, said because of some Maryland rules of evidence and because of the Maryland rules of procedure, you see, in Maryland, as I think then only in Indiana, juries in criminal cases were judges of both the facts and the law. Now, exactly why that produced this result, I don't know. But they said sent it back to the state and said you got to try him on. They affirmed the Court of Appeals of Maryland, which said you got to try him on punishment only. The prosecutors didn't know how to do that. It'd never been done. In all other trials, you know, you try all the facts, everything. And on the basis of that, the judge or the jury decide whether the person is guilty and what the punishment ought to be. So the state didn't know how to, you know, what are the issues then in a trial that's supposed to only concern itself with punishment? Of course, I would have argued if they'd gone ahead with the trial that they had to try him for the crime too, even though the Court of Appeals didn't say that, because that would only be the way they could give him the trial that he's entitled to that every other defendant had in Maryland. So the state didn't know how to try it. So Brady was in jail and waiting. I got him off a death row and into the general population by arguing with the warden that he wasn't under a sentence of death anymore. That had clearly been set aside. And so he went into the general population. And after he'd been there, I guess, 14 years, he and I decided that the state probably couldn't find the witnesses anymore. And so we asked for a new trial and asked for the trial. And the state's attorney knew he couldn't try it, and so then we said, well, why don't you, the governor could commute his sentence to life. And he did, and Brady I think had to serve 2 more years, was eligible for parole, and he was paroled. And I still talk to him from time to time. But I mean, the lessons, there are a lot of lessons in that case, one of which is, here I lost a case. See, the Supreme Court, it's apparent to me now that the Supreme Court wanted to announce this rule. They must have been seeing enough petitions for cert or cases coming before them in which the state had been withholding evidence, and exculpatory evidence particularly. And so they wanted a vehicle to announce that rule. And they took this case and decided against the appeal, affirmed the court below, but announced that rule. And that rule, I think, you know, changed criminal jurisprudence in this country considerably. So you don't always win by winning.
Right. In 1965, you became the first director of the Legal Services Program within the Office of Economic Opportunity, the first program of the federal government to provide financial support for legal services to the poor. I know Ronald Reagan and Nixon didn't like the program.
Who are they?
What challenges did you face pioneering such a program? And was there much resistance?
Yeah, the resistance was the challenge. The resistance came from state and local bar associations. The resistance came to some extent from ethnic bar associations, all of which I think were unduly concerned that they would lose business. Many of their members of ethnic bars and of local bars, county bars, they represented poor people. Some of them did it because they thought that was their obligation as a lawyer. Some of them did it in the hope that when the person left the office, they'd be hit by an automobile. I mean, it was a way of, building up your business by being open to help people. But they were concerned they'd lose their business. I think we convinced them sufficiently that if the tenant has a lawyer, the landlord's going to want lawyers so that they would benefit from it. They came around to support it. But if you look at I think I faced severe opposition from a leader of the Tennessee Bar Association. I think it was Tennessee. President of the Tennessee State Bar. And he wrote an article it's in the bar publication, bar journal of the Tennessee Bar, in which it begins et tu brute. And he accused me of efforts to socialize the legal profession. I got called, I went to a meeting of I was just there about a year, and I spent most of that year selling the program. I was hired basically, not because I knew much about legal aid, because I didn't. There were some other great people like Ed Spower and others here at this faculty who should have been hired. I was hired because I button my collars down and my ties have stripes. And therefore I was not threatening to the establishment bar. So I spent a lot of time going around and speaking at local bar associations. And I remember, for instance, once I went to speak to the Virginia State Bar. I walked in, there was a big poster that had me pictured as an octopus. I can't remember now what it said below it, but it said octopus or something. And so that's where and there were confrontations with, I remember going to a meeting of one of our tenets as a part of the Economic Opportunity Act was that these new legal aid, legal services offices had to be governed by boards that included clients. It was the maxim of, God, I forgot that now. Anyway, that the people served had to be represented making the policy. And I remember going to a meeting of the Association of American Law Schools, and a dean of a law school in New Orleans striding down the aisle aggressively and saying to me, "Do you mean to tell me that poor people are going to tell lawyers what to do?" There wasn't anything I could do but say yes. And so there was that opposition. There weren't many existing. And other opposition, interestingly, came from the existing legal aid societies. I mean, there's a history of this written by a man now a judge, Earl Johnson, called Justice and Reform, which is a history of the early years of the legal services program. He was my deputy and then became the director after I left. And he recalls, shortly after we were there, the National Legal Aid and Defender Association, which was the trade association, if you will, of legal aid societies, had their annual meeting in Scottsdale, Arizona. There weren't many legal aid societies then. And they called us out there and attacked us. They asked me to give a talk, and I gave a talk, and then a great lawyer from Covington and Burling, who was very much on our side in the thing, was with us, and we went to lunch together and planned how to respond to the attack that came right after lunch from the president of the Legal Aid Society. I mean, look, here in Philadelphia, the Philadelphia Legal Aid Society did not accept OEO money. Community Legal Services was created as a new entity to receive legal services money. So opposition came from lots of places. It's a pretty good book to read.
In 1966, you ran for the Maryland Attorney General position.
I don't remember that.
What motivated you to run? Who was your opponent, and what were the salient issues of the
I
campaign?
lost. I don't remember. What motivated me to run? There was the beginning or a regrouping of the Liberal Democratic Party in Maryland. Joseph Tidings had recently been elected as a senator. He had actually called me just before I went to OEO and asked me to run for governor. I can remember I was walking out of the office to go take a deposition. The woman at the switchboard said to me, Senator Tidings is calling. I said, okay, I'll take it, and I took it. He said, can you come over here? I want to talk to you about running for governor. I said, Joe, you've lost your mind. I can't do that. Goodbye. I got to go take a deposition. I really thought he'd lost his mind. I mean, the idea of my doing that was crazy. But then I went to OEO, and OEO was a life-transforming experience for me. Before that, I thought if you went past Hagerstown, Maryland, that you fell off.
Yep, my battery died here.
Sort of the brains behind his campaign that came to me one day and said, we'd like to talk to you about running for Attorney General. And I mean, seriously, I thought I've never done that, never run for political office. I'd like to try that. That would be, seems to me, a good experience and a good thing to do. And so I decided to do it. And our issue was, this is also a very interesting time because Johnson was president, but Agnew was the Republican candidate for governor. And Sickles, our candidate, we had a three-way Democratic primary. We had a liberal Democrat, Sickles, the guy that I ran with, another guy who was an establishment lawyer, who was a sort of he was the Democratic machines candidate, the guy who was the Secretary of State of Maryland and had been, I think, the Attorney General. He was the machines candidate. And then we had an Irish contractor who had run 14 times for office in Maryland and never won. And I put "won" in quotes because actually sometimes he had gotten more popular vote than any other candidate, but at that time we had you had to win a majority of counties, and he might have it's sort of like the Gore-Bush thing. He had the majority throughout the state, but he didn't have a majority of counties. So he had actually won sometimes, but not won. And he was the conservative guy, and he wasn't very bright beyond knowing how to buy road contracts and build roads. And so his platform was, your home is your castle. Now what your home is your castle meant was, keep those colored people out. It was a code word. So like when he went into Montgomery County is the bedroom county for Washington and Maryland. And it's a very liberal county and a very affluent and very educated county. I mean, when he went there to campaign, people would ask him what his position was on the war in Vietnam. I mean, when I went there to campaign for Attorney General, they'd want to know, they'd ask you questions like that. Now his response was, if they said to him, what'd you think about the Vietnam War? He said, your home is your castle. And he won the primary. And all the liberals then voted for Agnew. And you know what happened then? So it was an interesting campaign. Now, as long as this is going, I might as well change the history a little bit. Or at least, no, I should put this on the historical record. All right. When the campaign started, I was certainly seeded fourth among 4 attorney general candidates. I finished second, but I found out there wasn't any prize for second, so it didn't matter. It was a great experience. It was also a life transforming experience. I learned a lot about myself, and yeah, it was very good. And I went back to the firm. You may not have. Law firms then were fraternal organizations that you joined and stayed in. There weren't lateral moves. People didn't have portables. Can you imagine that? You know what portables are, don't you? Don't they have portables anymore? Portables are your clients you take with you.
Okay. And
you'll see advertisements about wanted litigation partner with substantial portables. At that time, you went to a law firm and it was like a marriage. You didn't leave unless you got caught in bed with the wrong partner's wife or you were drinking too much. It literally was like marriage. And but here I had gone off to do this thing with OEO. I didn't have a leave of absence from the firm. The firms didn't know about giving people leaves of absence. What they said to me is, first of all, some of the partners were certainly concerned that I was going off to this socialist endeavor of the war on poverty. I mean, it was not something that was high on their agenda. And so what they did, they said to me, we expect you to come back, and if you do, we expect to welcome you back, but we don't want you to feel obligated, which I think also meant we don't want to feel obligated, so they didn't give me a leave of absence. I came back, and they said, fine, but right after I came back, come in. I ran for Attorney General before I came back to the firm. I left OEO and ran for Attorney General. And then, so that indicated some instability on my part. And then after I'd been at the firm a little while, I now like to talk about the more important political campaign when I won. I ran for a delegate to a Maryland Constitutional Convention, and I won. Let's get that on the record, all right? And that may be very unstable. Here's a guy who'd taken 3 excursions out of the firm, in effect. And although I expected to stay there, but I didn't. And then a couple of years later, a guy I knew vaguely because I had hired him to do some work for me when I was at OEO, who was a member of the faculty at Catholic University. And Catholic University had a search team that was chaired by Justice Brennan, and on which Bob Drinan, later Congressman Drinan, Father Drinan, was a member of it. And Drinan and I had been law school classmates. And one of the clerical functions that Drinan continues to exercise, and I say this facetiously, is to meddle in other people's business. So he's always sort of would come up to me and say, what are you doing now? Well, you ought not to be doing that. You ought to go do this. And he was on this committee and decided that I should be the dean at Catholic University. And again, much like the Attorney General thing, I thought, well, I've never done that. I'd always taught part-time when I was practicing, and I thought that might be interesting, so I went off to do that.
Did you find teaching in academic administration more rewarding than private practice?
Yes.
Did you establish a clinical program at Catholic University?
Yeah, one of the first ones. See, because I always thought, maybe you should just instruct the witness to give you yes or no answers.
Oh, no. Please.
When I was at Piper and Marbury, I did a lot of work with Blue Cross in Maryland, which was then a nonprofit, and with the Johns Hopkins Hospital. And so I met a lot of doctors who were teacher practitioners. And I thought, what a good life. Wouldn't that be nice if in the law you could actively engage in practice and at the same time be engaged in teaching and research. So the idea of that attracted me to legal education, and then it was a wonderful time to go there. I went there in 1969. The young people who were coming to law school had been college students in the 60s. They were social activists. It was a time when the first women and the first blacks came to law school. And here I was at a law school in the District of Columbia that had no place to go but up. The District of Columbia was the best place to have a law school or any kind of student endeavor that were interested in social action. And I thought in sort of thinking about what the role of what they're now called faith, what are they called, faith communities? But then they were called what a church-related institution could do about the law. I thought the two great problems in America that faith communities in the modern vernacular ought to address were race and poverty. And part of that was my own experiences in the Civil Rights Revolution and in the War on Poverty. And clinical education tied into my interest in the relation between practice and teaching. And about that time, Ford Foundation funded a thing called CLEPR, in which Ed Spire was involved, Howard Lesdick was involved, and we got a grant to have a clinic at the law school.
What communities did the clinic initially serve?
Well, Catholic University is located in the midst of a middle income to quickly changing to poor population in northeast Baltimore, northeast Washington, and we I got a grant from a local foundation to buy a building about 5 blocks from the law school in a terribly depressed neighborhood. And I used the money to buy the building because I wanted to give some assurance of continuity. And I know that faith-based communities are very reluctant to ever give up real estate. And so I thought if they had the building, and so it was located in a very depressed, mostly entirely I guess African American neighborhood, 5 blocks from the school.
Were students received credit for their clinical?
Oh yes.
And were they obligated to participate in clinical activities, or was it a voluntary?
Optional.
Do you believe in mandatory clinical education for law students?
I think experiential education ought to be a part of every law student's experience. Now, that experiential education is a broader term than clinic, but you know you're not going to spend the rest of your life attending lectures and learning how to be a lawyer. Right. You're going to spend the rest of your life trying to learn how to lawyer from your own experience, and you ought to learn how to do that. You ought to learn how to understand your experiences. You ought to understand how to reflect on them and learn from them.
Do you think law schools on a nationwide basis are emphasizing clinical education enough today?
No.
How do you think clinical education contributes to a law student's academic experience?
Well, I think it does a couple of things. One, I think it is a way in which a student can learn whether she really wants to be a practicing lawyer or she wants to do other kinds of other skills that she learned, use other skills that she learns in law school. I think that, look, you know, we don't have, this country is a diverse country of diversity. We don't have a national religion. We don't have a national ethnicity. The thing that binds us together is law. And increasingly, we're excluding people from the law. 80% of the poor who need a lawyer can't get one. And a percentage nearly that big, I don't happen to remember what it is, of middle income and working people who need lawyers can't get them. Do you know that the United States provides the least resources for legal aid to the poor of any country in the world? Do I have to repeat that? You understand you're at the bottom. You thought we were high, didn't you? You thought we probably did a good job in this country. Did you?
Right.
Well, if you measure it, and I in my briefcase somewhere, I can give you a chart. If you measure it by percentage of gross national product, if you measure it by dollars per taxpayer, if you measure it by dollars per poor person, we are way at the bottom of the list of Western democracies, of Canada, the UK, France, England, Germany, I said England, the Netherlands, Italy. We're at the bottom of the heap. It's disgraceful.
And do you think law schools perpetuate this problem? In a speech that you gave to the 1981 graduating class at Penn, you said, law schools make us insecure in the ordinary law, the law for ordinary people. After 3 years of learning that there are no right answers, we are not confident about advising troubled and dependent clients. What do you advocate law schools do?
I don't even remember saying it. It sounds pretty good.
Yeah.
Somebody the other day, I was being introduced somewhere, and this nice person said, and Clinton Bamberger said and read a speech I'd given at a commencement at Catholic University, and I went up to her afterward. I said, I never said any such thing. I said, that was really good. Where'd you get that? Well, she said, I'll get you the speech. She did. No, law schools have little or no interest in it. Little or no interest. I mean, here you're a law student, and you didn't know that we do how many in the population of this country are denied access to the law. Because nobody talked to you about that in law school.
Right.
And I've just come from a conference in Boston as part of an initiative by the Association of American Law Schools to try to involve law schools with public interest law, with legal services programs. For the first time in its history, the Association of American Law Schools, which is the trade association of law schools, has elected a clinician as its president, a wonderful guy named Elliot Milstein from American University. And when he was chosen as president-elect, he set out on an initiative to create relationships between law schools and public interest lawyer, take a broad term. And they have been holding these colloquia around the country. I've only been to one, the one that I just came from in Boston. What upset me about it is that most of the faculty members there were clinicians. They were not stand-up faculty, as we call them, as I call them. Except the only other ones there were some people who came to law school faculties from legal services and retained some interest in it. And most of them came in to speak on a panel and then went home. They didn't stay for the rest of the day for the dialogue with the legal services lawyers and clinicians there. And I think the fault lies. You now got me on my hobby horse, all right? I've been on a number of hobby horses, all right, but this is the biggest one. Legal education and legal practice are completely divorced from each other. I think the reason for that is historical. Now, mind you, look, I have no footnotes to back this up. I'm not a scholar, okay? So somebody else can tell you this is all baloney. Well, what it will be called is anecdotal and anti-intellectual. That's what it will be called, okay? So I accept those terms. But legal education wasn't originally a member of the academy. Legal education most law schools, I think probably until the early part of the last century, were independent institutions. Many of them were run by in the major cities by YMCAs or Knights of Columbus as ways for immigrants to move into the profession. It's interesting, I was looking before we came up here, down where the goat is, there's a wall about the history of this law school, and you'll see that at some point. When this law school decided that it would become a real law school, the thing it said was, our teachers must be full-time, no practice. There's a letter on the wall there, and I wish sometime maybe you'd copy it for me and send it to me, in which the newly elected dean says to this newly appointed faculty member who's coming from practice, he says to him, you understand your office will be at the law school. You may, if you wish, have some consultations in the library, but your office is in the law school. And part of the reason for that, I think, is that universities were dominated and governed by arts and science faculty people, basically. And they saw law schools, they called them trade schools. And that offended the sensibilities of law teachers. And law teachers then had to get away from the trade and become pure scholars. I think that's a great loss. I mean, how is it in a country built on law, in a country in which, and what I said about law being kind of the substitute for our national religion or our national ethnicity, I didn't say that. I think John Sexton, a great dean at NYU, is the person I stole that from. But in a country where that is the truth, we are a nation of law, that if you look, you won't find many law review articles addressing the issue of why 80% of the poor can't have the assistance of the law, of why a majority of middle income people can't have the help of the law. That isn't a subject for them to talk about. Now, clinicians began to address that. And as I said up at this conference in my smart aleck way, in this conference in Boston, I said, you know, I had some hope that clinicians would kind of build again this gap between law and practice. But then I began to read articles in the Clinical Law Review that had in their titles words like lacuna and paradigm. And I know they'd been captured too by the Academy, and that the text didn't matter anymore as much as the footnotes. So that's my hobby. I mean, I really think it's a great, and the other, Langdell is another reason for that. And now I think I read this in something that Derek Bach, the former dean at Harvard, wrote. One of the things that Christopher Columbus Langdell said was that law is a science. Everything you have to learn is in the books. That's absolutely nonsense. Absolute nonsense. The law isn't all in the books. The law is in the practice. The law is in relations to people, to institutions, to government. Amen. Sorry.
Well,
I have 5 more minutes on this tape.
Okay.
So I think I should go get another reel.
I think we should quit.
I'm going to keep it rolling. And I'll be back.
I'll just ask one more question
All right.
related to that.
I mean,
There hasn't been
Okay,
any
do you wanna
question.
do-
There hasn't been any question I've answered in less than 5 minutes.
Along those lines, in 1986, you wrote an article published in the Rutgers Law Journal entitled Debilitating Conformity in Local Law Schools, whereby you stated national law schools don't do much critical analysis of the law because they have a stake in not doing it. The law as it is supports the interests of the clients and their graduates and the graduates they serve. Critical analysis of the law to learn why the law is what it is, what the forces are that made it what it is, who and what sustains it, and what the results are for society of no change in change would threaten the interests of the elite class served by the national law schools. How can we get national law schools to do more critical analysis?
I wrote that? I do remember writing the piece, but because you may be the only person who ever read it. I don't know the answer to that question, because I'll tell you, I mean, some very good people have criticized that. I just told you too. I mean, Bach, if you look at Bach's article. But it doesn't, I don't know. I don't know how you do it. I think we ought to begin to talk about it. Some of the discussions at this conference addressed that issue. Another thing that I again steal this from Sexton. Sexton was a theologian before he became a lawyer and a dean. And Sexton said that law schools, that he took sort of a lesson from the positive side of original sin. And that law schools, in the words of Martin Luther King, ought to sin boldly. And what we need is some national law school, and Penn is a good candidate because of its background. When Ed Sparrow was here, this law school was very involved in the practice. Ed taught from the practice. Ed taught from the lessons he learned in the practice. I'm sure that there's some others here who do. But essentially, law schools have been captured by corporations and major law firms. And that's who you cater to. The law school, before there was U.S. News and World Report, the quality of law schools was measured by the number of people placed in the major corporate law firms. Law deans got together and they didn't talk about their course content or contributions to social justice. They talked about how many people they placed at Cravath. That's anecdotal and anti-intellectual. Okay? Sorry. That's enough.
Well, thank you.
Okay.
It's been great. Appreciate it.
I get to edit?
I have a release form.
Obviously, I enjoyed it.
Excellent.
I got a copy I want to put in
Yeah,
our national.
absolutely.
Listen, I should tell you, we've set up a